topic I like to talk about often, wills and estates and estate planning. And the reason being is it touches our lives all the time. Wills, estates, power of attorneys, trusts, estate planning. And the reason I like to talk about it is, especially this time of the year, at the end of the year and at the beginning of the year, it should be on everyone's list. New Year's resolution to finish their will or their estate planning. But in addition to that, people should consider if what they have already in play is what they need. Because sometimes they think it's what they need and it doesn't meet their needs. And I can tell you that quite often I'll have a family come to me at the last minute and they'll say, you know, we need an estate plan and our loved one's in the hospital. And how do you do it all at the last minute? Like when they're living their last days, they don't want to be worrying about property and stuff. Like obviously it's a concern, and on occasion I have had to go to the hospital to help people with their paperwork. But the best estate plan is one that you don't need to redo at the last minute, something that you know is done right. Recently I had someone come to my office and I did an estate plan for his dad who's in his late 80s, and the doctors have given him a very limited time now. Thankfully, the estate plan was done in such a way that there's no paperwork to do. There's absolutely nothing to do other than all I could tell them is go spend time with your dad, because that's what's important to your dad. It's not like the property is no longer that important. So I'd like you to participate in a little vote and tell me who has a will. A will, a power of attorney for property, and a power of attorney for personal care. So there's 51 participants. I should see at least 50 people who have their will and their POAs done. So why do we do estate planning? What's the purpose of an estate plan or making a will? And some people will say things that are kind of negative, and they'll say, what do I care if I'm dead? And I've heard this comment before from people. A few years ago, I had a young man come to my office, and he said to me, John, I don't want to do a will. I know all about wills. His occupation was that he was a lawyer with one of the big firms. And I don't need a will because I have no one I want to leave my property to. The only property I have to leave is my house and my car, and my brother will get it anyway. So I said, well, what about your parents? He says, well, my parents don't need money. I said, well, your parents will be your natural heirs under the Succession Law Reform Act. Was he right in saying that? He was wrong. And strangely enough, and life is stranger than fiction, strangely enough, this young man younger than me in his early 50s, he passed away 2 weeks later. Wow. And it did cause a lot of problems for his family that he did not have a will, because he was intestate. And intestacy can take a little longer. So why do we need a will? A will appoints an estate trustee, and it ensures your family will be taken care of according to your wishes. If you're doing an estate plan, you also get a chance to do a bit of tax planning in advance on how you're going to deal with things. And there's quite a few estate planning tricks that may or may not apply to our seminar today. But this young man, he passed away, and what happened was his elderly parents, who were in their 90s, were very unhappy to have to become executors of his estate. And at the end of the day, it took us 1.5 years to probate his estate because he had his records in some disarray. And it turns out what I learned is he just was very late in doing all kinds of things. So it wasn't just his will and estate that he hadn't done. He hadn't done his income taxes. He still had the snow tires on his car, and it was in the middle of the summer. right? So he was just very tardy in doing things. But the three main reasons that we do estate planning is not for us, it's for the people we care about. So you want to provide for your family and the people you love. If you have a business, it's a way of maintaining your business. Even though you pass away, the business can still be operated. And in addition to that, if you plan it in advance, you may also be able to reduce taxes. So is everyone aware of what tax kicks in when you die? Is there a death tax? Does anyone know? I know there's 54 people here. Someone knows about it. Any accountants in the room? All right. So
Capital tax?
Pardon me?
Capital tax?
Capital tax. Did someone say capital tax?
Yes.
Yeah, I'm not sure if Canada has a capital tax, but there is something called deemed disposal. So that's capital gains. You're talking about capital gains, I think, right?
Yes, yes.
So what happens when a person dies is all the gains that they've had in their property gets triggered in the year of their death. So that could be a real problem, because if you have a few capital gains, if you're holding property, real estate, or shares, it gets triggered as an arm's length transaction. And if that happens all at once, what does that mean? You're going to have a big tax year. And even though you have a big tax year, you haven't really brought in any money. Although it's worth more and the government says we want our share, is there money to pay for it? There won't be money to pay for it until you sell the properties or until you sell the shares. If it's selling the shares, that's easy to do. Selling real estate can take a little longer. And as you know, the market's changing almost every day. So at the time of your death, a few months later, it could be 6 months or a year. And in the case of the young man who passed away, we sold his condo. It was a $2 million condo almost a year and a half later. Thankfully, it was worth a lot more a year and a half later. But the gain, the capital gain, if there was a capital gain, would have been triggered. His condo at the time of his death. In his case, the condo was his principal residence, so it wasn't taxable in that situation. But he did owe a fair bit of money to the government, and his mortgage payments were not made on the condo for over a year. So he was basically, his estate was basically in power of sale, and they couldn't sell the property because they didn't have a will. We had to do a special type of application under Intestacy Law. So we had to apply for a certificate of appointment of estate trustee without a will. So let's talk a little bit about wills. So I know a lot of you already have wills, and what I tell people is I offer a free service to review your existing will. Some of the things that I look for when I'm reviewing an existing will is I'm looking to see if it's an original. I'm looking to see if it has two witnesses, and I need to see their names and addresses on the will and some contact details. The witnesses cannot be beneficiaries of the will. And I'm also looking for affidavits of execution. I can tell you that I do review a lot of wills, and probably 25 to 30% are missing something. They're missing either the affidavits of execution. It doesn't mean that the will is invalid, but it does mean that we may have to go to court, to a judge, and spend several $1,000s to get an order dispensing with the need for the affidavits of execution. Okay. If it doesn't have two witnesses, it's invalid. Under the Succession Law Reform Act, it should be an original will, but I will tell you that I have probated a photocopy will. In one situation, we had a caregiver who destroyed the original will on purpose. And we were able to go to court and get an order from the judge to probate our photocopy will as an original will. And that was a special situation. I'll talk to you a little bit about that near the end if I have time. But basically, there's two types of wills that our Succession Law Reform Act allows. So Succession Law Reform Act is the law that governs succession with or without a will. So the wills that it allows for are holograph wills and typed out wills. So a typed will requires 2 witnesses. A holograph will does not require any witnesses. For a holograph will to be valid, it has to be wholly in the handwriting of the deceased and signed by the deceased. In absence of a will, we can also do an intestate succession application to get a certificate of appointment from the court, which used to be called letters probate of estate trustee without a will. So under intestacy law in Ontario, we seem to follow what the international law is on intestacy. So does anyone know what international law is on intestacy? This is one of the oldest laws that we have in our legal system, is succession law. Does anyone ever hear about it? So succession law began in pre-Roman times with the Etruscans. The Etruscans had very specific rules on who can inherit from a person, and they always followed bloodlines. They considered DNA to be the most important thing. So it was basically the bloodline would be to your descendants. Anyone ever see the Netflix movie Descendants? Someone must have seen it. It was Descendants was set in Hawaii. So if you want to have a nice setting to watch a movie on, a movie in Hawaii, Descendants was a great movie to watch. But basically, intestacy law says that your descendants, meaning your kids or grandkids, would inherit from you, and you really have no choice. Most European countries follow these rules of intestate succession, and they've been codified into their civil law. I know most European countries, Switzerland, France, England is different, but all the civil law countries, Russia, Iran, all follow the same rule of law. It's called table of consanguinity under intestate succession. So basically, your children and grandchildren would inherit first, and your grandchildren cannot inherit if your children are living. Your grandchildren have to inherit through your children. And if you have no children or grandchildren, then who inherits next? Does anyone know? Anyone there?
Cousins, brother, sister.
Brothers, sisters is a good guess, and I appreciate you participating because it's hard to talk by yourself for an hour. Okay, so I can tell you,
Parents, I think parents
is a very good guess, but it's not yet. So who would be the next person to inherit?
Parents.
Parents. So if you have no children, then your parents would inherit. And that's what happened to my client. He had no children, he had no wife, he broke up with his girlfriend, so he didn't care about who was going to inherit him too much. And he said, my brother will inherit through my parents after I corrected him. I have had situations where a young man did not have a will. He was going to the hospital for an appendix operation. Do you think an appendix operation is a simple operation? I would say it should be a simple operation. It turns out that his mother visited him in the hospital. His mother was terminally ill. She had advanced cancer, and she was much, much older. He was in his mid-40s. Any operation in the hospital can result in death because of the anesthesia. So even if it's a simple operation, there's a percentage of people that don't wake up from the anesthesia. And that's what happened to him. So he passed away. Before he passed away, he told his mother where he had money in his house. He did not have a will. So who was the beneficiary of his estate?
His mom.
His mother.
His mother passed away a week after he passed away. So who's the beneficiary of his estate?
His dad.
His mother's estate was the beneficiary for half. He had no children. He had no wife. He had no will. So his mother's estate, which meant even though his mother had passed away, it would pass through his mother's will to his brother and sister. And his mother told his sister that your brother has hidden money in the basement concrete floor of the house. It's all wrapped up in jars. Guess why he did that? Who doesn't put their money in the bank and keeps it in jars in the floor?
No taxes.
Someone that doesn't trust banks, or someone that doesn't want to pay taxes, or someone that's involved in illegal activity, right? Is that possible? So I don't know which was true of our client. I know that he was in the landscaping business and he was used to getting paid in a lot of cash. I also know that he didn't trust banks as well, because years ago he had invested in some bank shares and he lost some money. I don't know what the truth of it was. His sister told me that he was addicted to opiates because he had an injury with his leg, and he had chronic pain with his leg his whole life. So he was addicted to opiates, and he may have been dealing opiates. We don't know that for sure. But at the end of the day, what type of estate did I have to probate? I had to probate something called an intestate succession. Under the Succession Law Reform Act, the estate of his mother and his father would inherit him, his estate 50-50. Guess when the last time was that he saw his father? His father had abandoned the family when he was still in diapers. And his father had remarried and divorced and remarried again. And his father was in a nursing home in Quebec. They had never spoken his whole life. His father never shared any graduations, nothing. We tracked him down in Quebec, and he was okay on inheriting half of his late son's estate. So guess who's going to inherit this man now? His mother will inherit his mother's estate, and his father will inherit. And this was kind of a complex estate because we also had to deal with the money that was hidden in the floor. And we still don't know what the reason was. It was hidden in the floor, but it did cause a bit of stress for the family. And also it brought back a lot of bad memories for the surviving kids of this family, because they now had to deal with the father that had abandoned them. So all I can tell you is you have choices. You can make a will or not make a will. You can just leave it to intestate succession. Intestate succession is better than nothing. Some people will tell me, well, if I don't have a will the government inherit? Does anyone have an opinion on that? So Tara said something about income tax avoidance. So income tax avoidance is illegal, but income tax reduction is legal. We can legally reduce income tax. Avoiding income tax is a criminal offense under the Criminal Code of Canada. But I will tell you that the government would like to inherit. And who's the government? The government is the crown. So in Canada, the government always acts under the name of the Queen, under the regent. Recently, I had someone who came to my office who was a caregiver, and she inherited a condo and some money in the bank, and some gold coins that were in a safety deposit box from a gentleman. This gentleman had passed away. He had decided to leave everything he owned to his caregiver. For what reason? Even though he had 3 kids, he was estranged from his kids. He had separated with his wife. She remarried. His kids wanted nothing to do with him. Obviously, his wife had poisoned them, or maybe he just wasn't a good dad. We'll never know the story because I never met the guy. But he was in his late 80s, and he decided to leave everything to his caregiver. By the time he got to the hospital and he was in palliative care, a government officer came to visit him. And guess what office they were from? They were from the Ontario government, Office of Guardian Office, Ontario Public Trustee's Office. And they asked him if he had a will. He couldn't remember because he also had some dementia. As people get older, they get dementia. So guess who seized all of his assets? They went to his condo and they changed the locks. They went to his bank and they took the money. And they went to his safety box and they took the gold coins. Who was the legal beneficiary of his estate?
The caregiver.
In this case, it was the caregiver. In this case, the caregiver had been kind to him. She wasn't his current caregiver, but there's always suspicion when there's a caregiver involved because people believe that the caregiver will exercise undue influence or manipulate the person into leaving all the property to her. It turns out this gentleman's the office of government, the government office of Public Guardian and Trustee, Ontario Public Guardian and Trustee's Office, tried to find his kids, and it turns out he may have outlived his kids. So he was in his late 80s. But the reality is they couldn't be found, living or dead, and they weren't entitled to the estate. He had made a decision to leave everything to the caregiver, and we had almost a 1-year process of going back and forth with the public guardian and trustee to get information on the estate. Because when I have to probate an estate, I need information because there's a tax that has to be paid. So does anyone know what that tax is called? What's the tax that has to be paid?
Is that the inheritance tax?
It's a form of inheritance tax. In Ontario, we don't have inheritance tax per se, but we do have a death tax. They call it a probate tax. It's based on a percentage of the estate. And I'll talk to you in a couple slides more about what that number is. But for me to probate a will and to get the court to sign it, one of the steps that the court will look at is that if the taxes are paid. And who gets paid first? Whether you die or whether you live, who always gets paid first?
Government.
Government. Even before the mortgage, the queen gets her due. So I will tell you that any government liens go first. And if there's money owing to the government, you're not going to get that stamped paper. It's very hard to get it. So basically, now you understand what an intestacy is. You understand what a holograph will is, and you understand what a typed will is. Let me tell you a little bit about a will that I received a few years, maybe 10 years ago, that was both holograph and typed. There was a lady who passed away. I'm going to call her Auntie Phil, and Auntie Phil was in her 90s. It's kind of happier when it's not as sad if it's an older person in their 90s who's lived a full life. Her husband had predeceased her. They had no children. And Auntie Phil was very frugal. She saved her money. She had about $200,000 in the bank, and she had her house paid off in Scarborough. I think the house was sold in the end for $600,000. That was 10 years ago. So that was kind of an expensive house for Scarborough. She went to Staples and she purchased a will kit. Does anyone have a will kit will? You can use the chat feature and tell me if you have a will kit will. So I would tell you almost 50% of the wills I find with problems are will kit wills. And almost 50% of the case law that goes before the court is a will kit will. So she bought a will kit will. Because she didn't have a computer, she filled in the form that came with the will kit will, which was fill in the blanks. Is that a legal form? It was both typed and holographed. She filled it in by hand, but she didn't have any witnesses. She initialed every part that she filled in. She wanted to leave everything to her two nieces. Her two nieces would fly into Toronto from their country and take care of her and get her ready for the winter. They would spend the whole summer with her every year. For the last 10 or 15 years, they'd come and they'd spend 2 to 3 months with her, and they would stock her up. They'd put food in the freezer and portion control, and she would just have to heat up her meals. They'd shop for her. They made sure she had clothes. They would garden her yard, take care of her landscaping. They would take good care of their aunt. And she said that she promised her nieces that she'll leave everything to them. Can she do that? Is she allowed to leave everything to her nieces?
She can, but that will that you said, it doesn't valid, I believe.
Well, the will had a problem. Guess what the biggest problem was with the will? It was signed without any witnesses. So signed without any witnesses does not fulfill the requirements of the Succession Law Reform Act. If it's a holograph will, it can be signed without witnesses, fully written. Holograph comes from the Greek word all written, holographos. A typed will requires 2 witnesses, a holograph doesn't. In this case, we had a will that had no witnesses, so the will was invalid. So guess what I had to tell the nieces? I had to tell them, unfortunately, you're going to have intestate succession. And they said, that's all right, because we have there's no other relatives other than us. I said, well, what about your mother? They said, yes, our mother will inherit. I said, well, wasn't there anyone else? Were there any other brothers and sisters of Aunt Phil? They said, yeah, there was a brother, but he didn't have kids and he died before. He died quite a few years before. So in that case, we had an intestacy. They expected to inherit everything. The two sisters. I sent all the papers to the UK to be signed. Mother swore affidavits that the brother had no kids. One of the requirements is I have to do a little bit of due diligence before I process everything. And I ordered the brother's death certificate. It took me a while. And guess what I found when I read the death certificate? I found that the brother had a daughter who received the body for burial. So what had happened? Do you think they were lying to me? That there were no other heirs?
Of course there were.
I believe so, yeah.
Or maybe they didn't understand that brother's daughter was entitled to a portion of the estate. So for me to submit the probate to the court, I have to make sure I know the name and the location of all the living heirs if it's an intestacy. So I asked them for the address of their cousin, their first cousin. Who doesn't know their first cousins? I have about 18 first cousins in Toronto, and I never see them, but I know all their names. I kind of know where they live. Some of them I keep in touch with, some of them I don't. But the idea is the two sisters did not want to tell me about their cousin, that they might have had cousins. Why do you think that was the case? Paul is a very nice guy, and he says they may not have known about their uncle's daughter. It's possible, right? Maybe they didn't know. Maybe they lived in a different city. They lived in a neighboring city. One of them lived in Manchester, the other one lived in Leeds. So it wasn't too far away in the northern England. So I will tell you that I started to look for the missing daughter or the missing heir, and I started looking in Facebook, and I started looking in Instagram. Guess how common her name was? Her name might as well be Jane Smith, because I was finding so many people with the same name. And guess what letter I was sending to people? I was sending them a lawyer's letter that said, you may be the beneficiary of an estate. Is that possible? Who's going to reply to me?
Everybody.
No one replied to me because
Nobody.
no one, because they thought it was one of those phishing schemes. Okay?
You're the Nigerian prince.
I didn't want to use the nationality, but I'll tell you that it looked like a phishing scheme, one of those phishing schemes. So I will tell you that I was ready to give up. And at a certain point in time, the two sisters who brought me the estate to probate, they hired a lawyer in the UK, and that lawyer sent me a letter that he's going to report me to the Law Society for not proceeding fast enough. How could I proceed without finding the heirs? There was only one way for me to proceed without finding all the heirs and listing them. I had to list unknown heirs, and then I would have to get a bond because the court would not allow me to probate the estate without a bond. The cost of the bond is an insurance policy. The cost of the bond was a percentage of the estate. The first year of the bond was $60,000 in that case. It was huge. And the second year was $30,000. So who wants to spend $60,000 for a bond? It's a waste of money, isn't it? All they had to do was cooperate. So I dragged my feet on it, and then I found someone who was advertising in the Ontario law reports, missing heirs found. He was a genealogist, like a detective, and he says, I'll find your missing heirs. And I said, okay, what does it cost? He says, it costs you nothing. Isn't that generous? So what's the hitch when someone says something is for nothing? Some people say
There's a catch.
yeah, there's a catch. Some people say don't take something for nothing, and some people say if someone offers you something for nothing, take half. Does that make sense? That's an old saying, right? If someone offers you something for nothing, take half, don't take it all. But in this case, there was a catch. He was going to take 25% of the inheritance. And what did I tell you the inheritance was? $600,000 house, $200,000 in the bank. The two sisters who visited me initially thought they were going to get $800,000, $400 each. Now that we found that there is an heir, cousins, they're going to get $200 each. So right away, it went down to 50%. I still didn't want to give the 25%. 25% was a lot of money. I didn't want the heirs to say, why don't you post a bond and keep looking? So I went back to the person that got me the death certificate for their late father. He was a genealogist also. And he says, you don't have a missing heir. I said, what do you mean? He says, you know who the heir is. You just can't find them. They're not missing. I said, okay, well, can you find me government records that show where they live and their name and stuff? He says, okay, I'll find that for you, 200 pounds, 200 pounds sterling. So that was a good deal compared to 25% of the estate. So he found me the name of Jane Smith and her address. Her name was no longer Jane Smith, it was Jane Jones. She had remarried. So Jane Smith was her first married name, and she split, she divorced, and then she had remarried, which is common for 50% of us. 50% of the population will divorce. 50% of all marriages end up in divorce. So what had happened now? So she had moved, she lived within a few miles of the cousins. I had her address, but I didn't have her phone number. So I sent her a letter. You know what lawyers' envelopes look like. They're always legal size. And I sent it registered mail, so it had lots of stamps on it and decoration and stickers. It was in the month of November. And guess what? It came back undelivered. unaccepted. How's that possible? This is because of the intestacy, and I had to find them. So it came back unaccepted. Why would someone not accept a registered letter? Any comments on that? Anyone ever receive a registered letter?
Perhaps they thought they were in trouble.
Registered letters can mean someone's suing you, or maybe you owe money and they're looking for you, right? Or maybe someone's going to cancel your insurance policy. I don't know the reason, but for some reason, people are afraid to accept registered letters. Or maybe the postman came to the door and they have a problem answering the door, and it was sent back. So I was kind of shocked. It came back the first week of December, and I was very frustrated because I was getting the lawyer for the two sisters threatening to report me to the Law Society for not being quick enough in probating the will. But right now, I don't trust them, the two sisters. So I'm going to take my time to probate it because I'm the executor of this estate, and I have a legal responsibility to the beneficiaries and also to CRA to make sure the estate is properly dealt with. So I had this idea, which is not, it's kind of a different thought. We were giving out Christmas cards at the time. I don't send out Christmas cards anymore because I have too big a mailing list. But at the time I was sending out Christmas cards, and it was 10 or 12 years ago. And I took one of the Christmas card envelopes, and you know, those have an odd shape. They're kind of square. And I put my letter in the Christmas card envelope, and I mailed it again, regular mail. And guess what happened within a week? Within a week, I got a phone call, and it was from Jane Jones. She says, "I'm Jane Jones. I got your letter. So do I believe it's her?" I said, "What was your father's name? What was his birth date?" So she assured me that she knew who her father was. And I said, "Do you know that you have an aunt who passed away?" She says, "Yes, Auntie Phil, I know all about it. As a matter of fact, I visited her before she passed away." I said, "And how did you find out she passed away?" She says, "My other auntie told me. The other auntie who swore the affidavit that her brother had no kids." So what does that tell you? They were hiding.
There is another sister over there. There is another one.
She says to me, "Listen," she says, "John, you sent me this letter. What about my sister? Why doesn't my sister get a share too?" I said, "I didn't know you had another sister." So basically, it was a big secret. They didn't. The cousins were estranged, and the one set of cousins didn't want the other set of cousins to inherit. So at the end of the day, we had to probate this estate. The beneficiary, the sister who was the beneficiary, who would have left everything to her two daughters, she actually passed away before I probated the estate. So who was entitled to inherit from the sister of the beneficiary sister, the mother of the two sisters?
The two nieces, the two sisters.
The two sisters plus their brother that they didn't tell me about. They also had a brother who lived in Australia. So it was a big game. This was 60-year-old people, adult people, who were in good health, that were trying to cheat their relatives, including their own brother of an estate. Whenever there's money to be inherited, for some reason, people lose all of their morality. I've seen it time and time again. Everyone thinks that they're entitled. I don't know why that's the case, but that's the reality. At the end of the day, the two sisters were entitled to 1/3 of 400,000, as opposed to 50% of 800,000, what they expected. And I'm very thankful that I took my time. And when someone says go faster, you'll see me slow down, because that means someone's trying to rush me to pull a fast one on someone else. And I'm not going to let that happen. So basically,
in this case, wouldn't the two nieces have been able to fight for it, just because of the fact that the Auntie Phil had originally left it all to them, and that's what she had intended with her money.
Auntie Phil, if she had intended to do it, she should have hired a lawyer to do a proper will.
Damn it.
Just like the older fella who left everything to his caregiver. He left everything to his caregiver because the caregiver is the only person that cared about him. And even after she stopped being his caregiver, she kept visiting him. She kept visiting him. She kept in contact with him. Even when he was totally incompetent, she made some efforts. The Office of Public Guardian and Trustee, they just assumed that there was no will. They couldn't find the will, so they took over his estate. Public Guardian and Trustee will always step in, whether it's someone living or if someone's living, to take over their estate and their property. And I can tell you on many occasions, I've had family members come to me and tell me a story. Like one story I've heard is my mother is a hoarder, and we want to move her to a long-term care home, but we don't have a power of attorney to deal with her property or to deal with her personal care. And there's only one way to deal with those things is to get the Office of Public Guardian and Trustee involved. But as soon as they're involved, you're not directly involved anymore. So a more common story is we'll apply to the court and we'll join the Office of Public Guardian and Trustee in the application to get an order allowing the children or the person who does have the time to take care of mother to step in and take care of her affairs, to sell her house, to empty it, and to find a care home for her. So when does a will have to be redone? So imagine everyone is good and they're not intestate. When do we need a new will? Does anyone know? So if you need a new will, this is one of the things I look at when I give a free will review. What if your executor has passed away or is no longer capable of acting for you? Or what if you've fallen out with them? Imagine you picked your best friend 30 years ago to be your executor, and now you're no longer friends. What does that mean? Do you still want them to be your executor?
No, you need to redo it.
You would need a new will.
Yeah, so that's one reason to change your will. I have seen people that are executors not wanting to act if they fell out of favor with someone. Usually you pick an executor over your kids if your kids are underaged. So if you have kids under 18 years old, you're going to pick maybe your best friend or your cousin or an uncle to be an executor. Usually I recommend that once your kids reach legal age, that we appoint them, that we do a change to the will. It can be done either redoing the will or through a codicil, which is like an amendment to the will. And that's how we would change the executor. Another reason to redo a will is if you have a change in marital status. So under the Succession Law Reform Act, any change in marital status, that means marriage or divorce, that renders your will invalid. Does that make sense? So if your will is invalid because of a change in marital status, who inherits you? You go under the laws of intestate succession. Does everyone know that? So if you've married, your spouse will not inherit you automatically. Who would inherit you? Intestate succession. Children, parents, and the spouse will have the right to a preferential share of your estate before children and parents get anything. The first 200,000 of the estate, and they'll have to apply through a court process. Okay. What's another reason to redo your will? To revise a will, if the needs or the identity of your dependents change. So what needs of your dependents would change? You may have a dependent who needs long-term care or is not competent, and we have to do a special will for them that puts money into a trust. We call that a Henson's trust. And obviously, capacity is always an issue. If there's a change in capacity, then you can't change your will. Okay.
Can I ask you a question? If you do a marital status, it's only divorce or separation or just letter of separation? What kind of status?
Oh, you
talking
asked the
about?
best question.
Oh,
You asked a very good question. So I know a lot of people can separate, and they do a legal separation. And legal separation does not invalidate your will. Only
has to be divorced.
only divorce invalidates your will. So if your spouse was named in your will, they're still your spouse. They still will inherit you as a beneficiary. So if you separate, that would be another reason to redo a will. But it doesn't invalidate your will.
Good answer.
Well, it was a good question. So basically, quite often people, when they separate, they'll do a new will and not leave anything to their spouse. And when they divorce, we'll re-execute the will again. Okay. And in the new will I do, I'll say this is in contemplation of divorce, and there's a higher chance of it not being contested. But I will tell you that sometimes people will call me and say, John, I want you to do a will for me, and I want to leave everything to someone. So I've had one of the problems with doing wills for people who are elderly is if I don't know them very well, I'm never sure of their capacity. What does capacity mean?
Are they sick?
Yeah, it's sick. It's a mental capacity. Mental capacity means being able to understand the consequences of their decision, understand information, and understand the impact of their decisions. They have to be able to understand their obligations to others, and they have to understand what their estate is. So if someone is penniless, they can't think that they're richer than anyone else. They're like basically capacity has a clinical meaning. Understanding these decisions. Often I get people asking me to go to the hospital to do a last-minute will for people who've never had wills. So what's my worry? My worry is maybe they have a will, and I'll be interfering with that because they don't have capacity and they may not remember. I did have a fellow call me from Sunnybrook Hospital, and he says, I want you to do a will for me. It's an emergency. I'm terminally ill, and I want to leave everything I have to my pharmacist. It's a true story. So what did I say? Truth is stranger than fiction. So what's my first thought about this? My first thought is that he doesn't have capacity, or maybe the pharmacist is influencing him in some undue way by withholding drugs. Is that possible? You have all these thoughts. I don't know what the situation could be. The situation could be anything. So I refused to do the will for him. And guess what he said to me? He said, okay, he says, send me to someone else who can do it. So I referred them to a lawyer who just specializes in wills. So my main practice is real estate, but 25% of it is wills and estates. So we do a lot of wills and estates, and we identified the estates that are too complex. I try to do economical wills and estates for people that are not high cost. So for under $1,000, we can do a very good will for people. Usually it's around $650 for most people, and that includes a will that's been carefully drafted, a power of attorney for property, a power of attorney for personal care. So I did send him to a more expensive lawyer who will spend a lot more time on it, and that lawyer refused to do the will. A week later, the gentleman called me again. He says, please, I want to leave my estate to this person, to the pharmacist. So I said, okay, for me to do this for you, I need you to engage a capacity assessor. You have to explain to the capacity assessor your story and why you want to do this. And she's going to give you some tests and write a letter to me that you're competent and the reason why you want to make such a will. So when I received a 4 or 5 page memo from the capacity assessor, I was totally impressed with who the pharmacist was. The pharmacist was a neighborhood pharmacist who had been taking care of this gentleman and his mother for the past 40 years. They not only were their pharmacists who were across the road from their apartment building, but they also helped them fill out their income tax returns. They helped them apply for government subsidies. They went grocery shopping for them when they couldn't. And before this gentleman's mother passed away, she told him, if you don't have someone to leave everything to, leave everything to the pharmacist family because they were really good to them. So my suspicion, so everyone can have a suspicious nature, I was very suspicious of undue influence. After I read the capacity assessor's letter, I was very impressed with this situation, and I understood that it was a just outcome. The gentleman had no natural heirs. If he didn't leave everything to the pharmacist's family, it would have escheated to the crown. It would have gone to Her Majesty, and he wanted someone to get it. So we did do a will for him, and what I learned later is that he did gift most of the property to the pharmacist while he was living, as his condition went progressively worse and worse while he was in palliative care at the hospital. But I've used capacity assessors on numerous occasions to do wills for people. And I will tell you that quite often, the story is very different than when we think it is. On some occasions, I've seen people take a will that I've done and they've redone it. They've done it over again. Why would they do it over again? Because their needs changed, possibly. On one occasion, we had a family whose needs had not changed. I had done a husband and wife's will when they were in their 70s. They had sold their house and they had sold their business, and they had rented an apartment. They had several $1 million in the bank, and they were leaving everything to their two sons. For the one son, we created a Henson's Trust because he had a disability and he wasn't allowed to hold money, otherwise he'd lose his government stipend, pension, and the other son would be responsible for him. And just before the father passed away, the mother had already passed, just before the father passed away, guess what the caregiver did? She took him to a local lawyer and he left everything to her. So guess what the outcome of that was? Could I probate the will? Every will that you do starts off with certain words, and they say, I revoke all my prior wills. So which will is valid? The new will or the old will? Anyone have an opinion on that? Is anyone still there?
Yes.
I still see over 50 people here, so you must find this
The
interesting. I know I'm going to go 5 minutes over, but
New
it'll
one.
be worth
New
it.
will, the
It'll be
new
worth it.
one.
You're saying the new one. So the son called me after his father passed away, and he says, I want to know the date of my dad's will. So when I read the date to him, he says, darn. He says, my dad did another will. He assumed the same thing, that the new will is valid. But guess what I found in the file in addition to the will? I found a mutual wills contract that I had done for father and mother while they were in good health and sound mind. Mutual wills contract prohibited the assets from being transferred to another person other than their natural heirs, other than their children, in the will that I did. So I was able to send my will and my photocopy of the will and the mutual wills contract to the lawyer who was trying to probate the estate in the latter will, and guess the reply I got? He said, okay, we're not going to probate the estate. So guess what my problem was now? My problem was that my clients had taken the original will and I only had a photocopy. Can I probate a photocopy? The court requires an original will to be probated.
No, original.
In fact, we did probate a photocopy, but we had to do an extra court application to because the caregiver had destroyed the will. We did a court application, and the court recognized our photocopy as the original, and it gave it the full force of the original. So although the caregiver had received a lot of money from the deceased before he died by way of checks and gifts, he was entitled to do that, and they didn't challenge it. They were able to save the bulk of the estate for the two sons and the one son who was handicapped. So the idea is that there's a lot of options. Mutual wills contract is a very good option for people. So it allows the survivor of the two to use the money to live a comfortable life, and then whatever is left over is held in trust for the beneficiaries of the will. They're not entitled to redo their will. If it does get redone, the benefit that they received from the deceased spouse goes directly to the kids. So that's what a mutual wills contract, it creates a trust. So basically, the last few things I want to tell you is, yes, there's a tax. I tell people it's about 1.5% of the value of the estate. On $1 million estate, it's $15,000. There's ways of avoiding probate tax. You can give a gift before you die. You can put, if it's real estate, you can put a joint ownership into a tenants in common ownership. So the surviving tenant, or sorry, the other way, make a joint tenants ownership. So the surviving tenant benefits before the will, and it gets transferred automatically. We can do transfers to a trust and various estate freezes. There's quite a few ways to save tax. And if you have shares in a privately held company, we can also do dual wills to avoid money passing through the estate. A dual will is a secondary will for property that doesn't need probate. So if anyone owns real estate in holding companies, we can pass the real estate through a dual will, and we can avoid probate, totally avoid the probate and avoid that tax. If you have a PREC, you can also leave the assets of your PREC under a dual will. Does anyone have a PREC yet? Anyone using a PREC? Right? So basically, there's a lot of ways to do estate planning. I do simple estate planning for people. It's not too complex. There's lawyers who just specialize in estate planning. If you have a complex estate plan, high value estate, I'll be happy to refer you to someone. Other documents that we need are power of attorneys for property and personal care. If you end up with dementia or lose capacity and you can't deal with your property or make decisions for yourself, if you don't have this document, again, Ontario government, Office of Public Guardian and Trustee will take over. Your family will not want that. They'll want to take care of you. These documents I do with the will. It's included in the $650 that I charge. I've talked about this already. There's also various trusts that we can create. I'm going to run a little faster through this. If you're making an offer in trust for a company to be incorporated, you may end up with personal liability. So sometimes I see people write in trust for a company to be incorporated. That's nonsense. It doesn't help your client by writing that. I will tell you, incorporate the company in advance before you make the offer, or use an assignment clause that relieves them of liability. Okay. These are my coordinates. Estates, wills and estates is a huge topic. I can tell you that if I review, there's 59 people participating today. If I review 59 wills, I will find 8 to 10 of them that need some tweaking. Usually I don't do it to say, go to, so I can make a fee. Usually I'll tell you, go to the person who prepared it and have them fix it. Does that make sense? And I'll tell you what's wrong or what's missing. On many occasions, I have wills without affidavits of execution, and I've had to track down the preparer, the person who prepared it. It may be a lawyer, it may be someone else who prepared it, and they can't remember, or they have dementia and they can't give us an affidavit of execution anymore. So that will involve a court order to dispense with the affidavit of execution. And then a $350 will turns into a $3,000 or $4,000 court order to get it done. All I can tell you is if your documents are not in order, and you're dead, it won't matter to you, but it will matter to your family because they're going to have a lot of trouble sorting things out. So Isabel, thank you for the opportunity today to speak to everyone.